Hello, everyone, and welcome to the 2022 Spring Landlord Seminar. My name is Brian Corrigan, and I am the Law Director for the City of Lakewood and host for today's seminar. On behalf of Mayor Megan George, we offer this seminar to provide the information you as a landlord need to offer a safe, quality rental experience and to help you navigate through the city's ordinances, building department requirements, and other laws that you as a landlord may face. City Hall and the building department are open to the public, but nearly all the required forms, permits, and payments can be done online through the city's and the building department's website. The building department is always available for phone calls to help you through if you are having difficulty or if you just want to stop down and make a payment down there or pull a permit down there. They are there and ready and available to you. There is a manual that the city has put out that is available on the city's website. It's called Best Rental Practices. And there are a few hard copies available here at City Hall as well. But this is available on the city's website. And this is a valuable resource that has a lot of valuable information that you may find useful as a landlord. And it's a manual for Lakewood landlords. Today's speakers we're honored to have and introduce for the first time at this seminar is the new municipal Lakewood judge, Tess Neff, to introduce herself and give some brief comments. We have Tanisha Hunter from the Fair Housing Center, our building commissioner, Chris Parmele from the building department, and Andrew Fleck from our prosecutor's office to discuss the nuisance ordinance and how the nuisance ordinance affects you as a landlord. So without further ado, I have the honor of introducing our new municipal judge, Tess Neff. Judge Neff, the floor is yours.
Thank you, Director Corrigan. Welcome, everyone, and thank you for taking the time to educate yourself on landlord-tenant issues. A little bit about me. I was just recently elected this past November to Lakewood Municipal Court Judge. However, I served in the same court for 10 years as a magistrate, and I heard the housing court docket. So I was in the unique position to decide cases, hearing both the tenant side of the issues and the landlords. And actually, it was one of my favorite part of my job when I was here. In addition, I've lived in Lakewood over 33 years. My husband and I raised our children here. And for the first 10 years, we were tenants living in a duplex. And then we became landlords. So I see the issues from both sides of the aisle, which I think gives me a unique perspective and some added experience that others might not have. So I'm going to touch on a couple chapters of the Ohio Revised Code. There is no way I can go in detail on everything, so I urge you to take the time to educate yourself, and I'm going to give you a resource at the end, in addition to what Director Corrigan said the city has available to you. First off, it's Chapter 5321 of the Ohio Revised Code that governs residential leases. It sets out the obligations of a tenant as well as a landlord, and it's critical you familiarize yourself with that, as well as have your building managers or agents who may be appearing on behalf or acting on behalf of you as a landlord. They need to know these laws as well. So a landlord-tenant relationship must exist in order for 5321 to kick in. And that happens when you as a landlord deliver possession of rental property to the tenant, and there is execution of a rental agreement. Now, a rental agreement or a lease, they're interchangeable terms. It can be written or oral, but it must establish the terms of the lease, the rules, conditions, and the regulations. And that is all set forth for you information in Chapter 5321.01D. Now, there's certain terms in a lease or rental agreement that you are prohibited from including. For example, you as a landlord, you have certain obligations. You can't contract those away. That would be prohibited. Just the same, you can't make an agreement that would limit your liability in particular situations. So that's something you need to familiarize with yourself so that you don't make those mistakes. So rent is typically an exchange of money for the use and occupancy of premises. The terms in the rental agreement should include the amount due, the time and place of payment. Now, this is important because if you have a written lease or agreement, it should contain in that written document the amount of the rent and where it's to be paid. So if it's mailed somewhere, the address needs to be in there so the tenant isn't confused on where he or she is sending their rent. Likewise, if you have an agent or yourself, you'd like to go pick up the rent in person, you need to set a time for the tenant to do that and make arrangements. Keep in mind, if you accept late or partial rent on a continuous basis, you may give up your right to evict a tenant for unpaid rent if that issue would come up, because you just took away the terms of the lease by actually breaking your own lease. So you would have to reestablish with that tenant that you are no longer accepting late rent. And I would advise that you do that in writing. So keep that in mind. And we all want to be helpful to our tenants. You know, they're running short, particularly if they're wage earners. They work in a restaurant. Maybe they didn't make the tips they needed to that month. But just be careful if you want to evict, because once you establish that pattern, it's hard to go back. So very important for landlords, Ohio Revised Code 5321.04. These are your obligations. There's 9 of them set forth. I am not going to read through the list. You as a landlord need to be responsible and, as I said, educate yourself. But some I want to highlight is you have to comply with the building and housing codes. And I believe Chris Parmele is going to address some of those issues for you. You're responsible to make repairs to the premises. And you can't abuse your right of access. You just can't show up at your tenant's place where they reside. It's their home, and say you want to be entered in. So there's certain rules for addressing those. So I suggest you read that statute very carefully. Now the counterpart to that is 5321.05. Those are the obligations of the tenant. Like you, tenants have obligations when they take possession of your property. They're responsible to keep the premises safe and sanitary, dispose of garbage properly, and they can't disturb the peaceful enjoyment of other tenants. So for example, say you own a 4-suite apartment building and there's one tenant that's playing loud music. That tenant could possibly be in violation of their obligations by disturbing the other tenants, and it may be something you have to address down the line. So landlords, you have several remedies if there would become a situation where there's a breach of the lease agreement. You can evict a tenant, you can seek monetary damages for unpaid rent or damages beyond ordinary wear and tear to the premises, and also possibly attorney's fees. So where that would all come in is when you file what's called a forcible entry and detainer action. This is a different statute than 5321. You need to also familiarize yourself with 1923, which is the claim for eviction. Now, before you get to that point, you may want to terminate your tenancy. Say, here's a good example because this just happened in our court. Old landlord sells to new landlord his property. With that property comes a tenant who already has a lease. New landlord wants to terminate the tenancy of that tenant. So what that new landlord had to do was file what's called a 30-day notice. And it's important to know when to file that. For example, if rent is paid April 1, the 30-day notice, if you want that tenant out at the end of April, you need to serve that at the end of March. So you could serve it March 31st. If you would happen to serve that 30-day notice April 1, that tenant can stay all through April and all of May, because when you serve the notice, you enter that periodic tenancy. It may sound confusing, and it can be, and that's why I urge you to really educate yourself on that. And in addition, you need to know the 30-day notice to terminate a tenancy is not the same as a 3-day notice to evict a tenant. They're two separate and distinct notices. So it's really important you're aware of that. You do not have to serve a 30-day notice, for example, for cause, if it's an unpaid rent issue. Okay, so back to the 3-day notice to vacate. That's outlined in 1923-04. First of all, it must be, the mandatory statutory language must be contained in that notice, and that's outlined for you in the statute. It's about a paragraph long. You need to familiarize yourself with it. That 3-day notice must be in writing. It must be conspicuous. And as I state, I can't state this enough, it is separate and apart from a 30-day notice. For example, the example I was just talking about earlier with the new landlord who acquired the property, he made a mistake. He gave his 30-day notice, so the tenant had until December 31st of this past year to vacate the property. He made the mistake of filing the 3-day notice on December 29th. He didn't give the tenant the opportunity to leave on his own, you know, in that 30-day period. So the 3-day notice wouldn't kick in until that 30-day expired. So there's a lot of time issues with these notices that could be a little confusing. And when you serve your 3-day notice, if you're wanting to evict a tenant, you always have to remember the day you serve it does not count toward that 3 days. For example, you serve your tenant a 3-day notice on a Monday. Day 1 starts Tuesday, day 3 is Wednesday, day 4 is Thursday. So Thursday is the day where the tenant needs to be out. If they are not, then you can pursue your eviction claim. And when you serve that 3-day notice, you could do it by certified mail. You can actually deliver it to the tenant and hand it to them, or you can leave it at their usual place of abode. If you know where they work, they report every day, you can leave it there, or the actual premises. You can place it on the front doors, you know, where they can see it and it's not going to blow away. Once that process is complete, then you can follow through with serving the summons for them to appear in court and the complaint for eviction. That can be done by ordinary mail. However, you have to give additional instructions, whether you want that personally delivered to the tenant, if you want it sent to the rental property, or posted on the premises. You do have the option of certified mail as well. And if you are successful on your eviction claim, which is often referred to as a first cause of action, you can pursue your claim for monetary damages, which is often referred to as the second cause of action. So that would be for any unpaid rent that you believe you're owed and any reasonable late fees. But those late fees have to be known to the tenant. For example, they have to be a part of the lease. You can't make them up after the fact. And you can also receive damages to the property that are beyond ordinary and reasonable wear and tear. And there's a lot of case law out there that explains what that means. So in closing, there's just a few things I want to point out. And one book I want to show you, which is really a great Bible for landlords and tenants, and attorneys use this. It's the Ohio Landlord Tenant Law. It's soft covered. It's like a textbook. You could get it, I think, anywhere. It's worth the investment because the way it's written, it's in layman's terms, and there's Q&A in there. There's sample forms so that you, and it's a great guide for tenants as well. And a lot of courts use it. I've always used that, and it's just a good resource. And I think some things you need to consider as a landlord when it comes to non-payment of rent, you know, inquire with your tenant. Why aren't you paying it? What's going on? Because especially in today's world, I mean, with the pandemic, we don't want to beat that. You know, it's been around for 2 years, but people have real issues, and it may be better for you financially as well to mediate your case with a magistrate, to work with the community resources, because we all know it's expensive to re-rent property. There's downtime to ready the property. You know, you may have to repaint. And if you have a good tenant, you really don't want to lose them. And I'm sure the tenant doesn't want to leave either. So those are some things I would encourage you to consider. Eviction, I think, should be a last resort. And the court is here to always help you and mediate, even set up a payment plan with your tenant. So thank you very much. I appreciate the time, and I hope you are successful landlords and you have great tenants. Thank you.
Thanks, Judge. Our next speaker today is Tanisha Hunter from the Fair Housing Center. And Tanisha, I think, has a PowerPoint and is going to talk to us. So the floor is yours, Tanisha. Thanks.
Thank you, Director. Let me just set this up here. Great. So again, my name is Tanisha Hunter, and I am the Director of Education and Outreach at the Fair Housing Center for Rights and Research. This presentation will provide general information. So for any specific legal advice, we do recommend consulting an attorney. The Fair Housing Center for Rights and Research is a not-for-profit fair housing agency that promotes equal housing opportunities and positive race relations in Northeast Ohio. Our mission is to protect and expand fair housing rights, eliminate housing discrimination, and promote integrated communities. We advance this core mission through some services, which includes advocacy, complaint investigation. Our advocates are available to assist victims of housing discrimination and offers free assistance to victims in the administrative complaint process. Enforcement, research, and just like today, education and community engagement. The Federal Fair Housing Act was signed into law on April 11th, 1968 by President Lyndon B. Johnson. Fair housing is a right afforded to all people living in the United States. Federal, state, and local fair housing laws exist to protect people living in the United States from housing discrimination. Over the years, there have been many policies and practices that were put into place that have perpetuated discrimination in housing, whether it was racial residential segregation or forcing people with disabilities to live in segregated housing. When the law was signed into place in 1968, it had two goals. One, to eliminate housing discrimination, and then also to promote residential integration and undo the effects of prior discriminatory policies and practices, which is also known as affirmatively furthering fair housing. The Fair Housing Act defines the term dwelling in very broad terms. So some examples of some covered properties under the Fair Housing Law includes homes, apartments, condos, manufactured mobile homes, nursing homes, assisted living facilities, residential recovery housing, transitional housing, dorm rooms, extended stay hotels, timeshares, and even vacant land intended for residential construction. Protected classes. The Federal Fair Housing Act has 7 protected classes, which includes race, color, and this can actually be intragroup discrimination. So for example, members of the same race might discriminate because someone is too light or too dark. National origin includes birthplace, culture, and language. Religion, sex, which now federally includes sexual orientation and gender identity. Familial status, which is the presence of children under the age of 18 living with a parent or a guardian or a person in the process of securing legal custody, and also includes pregnant women. Disability, we'll talk about just a little bit later. Ohio then has some additional protected classes, which includes ancestry, which is a somewhat broader term than national origin, military status. And then in Cuyahoga County in 2018, legislation was passed to include sexual orientation and gender identity before it was allowed on the federal level. Then, depending on where you might own property, there may be some additional protected classes, which might include, again, sexual orientation and gender identity, gender, marital status, parental status, source of income, creed, physical characteristics, age, and then even associations with a protected class. protected classes that you see on the screen here that have an asterisk by them are all protected classes included in Lakewood's Fair Housing Ordinance. Now, let's talk a little bit more in depth about protections for people with disabilities. The Fair Housing Act, the Americans with Disabilities Act, also known as the ADA, and Section 504 of the Rehabilitation Act protect individuals with disabilities from discrimination in housing, including individuals with mental health, intellectual, or developmental disabilities. Often these laws overlap in their coverage, but some housing may be covered by only one of the laws, while other housing may be specific to 2 or 3 of the laws. Titles 2 and 3 of the Americans with Disabilities Act prohibit discrimination on the basis of disability in all programs, services, and activities of public entities and by private entities that own, operate, or lease places of public accommodation. So what that means for a housing provider is that if you have a private entity that's a covered dwelling under the Fair Housing Act that includes a public accommodation, ADA laws would pertain to that property. Disability definition under Fair Housing Law. A person is protected as a person with a disability under Fair Housing Law if they meet one or more of the following conditions. Have a physical and or mental impairment which substantially limits one or more major life activities. A major life activity might include seeing, speaking, breathing, working. Record of having such impairment, being regarded as having such impairment, and also includes people associated with or residing with person meeting definition. So some examples of covered disabilities under the Fair Housing Act includes chronic mental illness, hearing, mobility, and visual impairments, cancer, AIDS, HIV, developmental disabilities, and then also alcoholism or past drug abuse. The Fair Housing Act does not protect current illegal drug users and anyone who poses a direct threat to the health and safety of others or causes substantial physical damage to the property. The Fair Housing Act includes some additional protections and special considerations for persons with disabilities. This includes a reasonable accommodation, which is a change to your policy or procedure that governs the residence, and also a reasonable modification, which is a physical change to the property. There are also new construction requirements that equal 7 accessibility features on new construction, which we'll talk about in just a little bit here. Some examples of reasonable accommodation requests, which again is a change in the policy, is to allow service animals despite you having a no pet policy, informing others such as a family member or social worker of new policies and procedures, allowing the non-tenant to use the laundry room if your tenant is unable to do so, moving from one unit to another without a fee, reserved parking spaces, allowing a live-in aid, changing the rent due date. So for example, if a person receives their disability income on the 3rd Wednesday of the month, allowing them to change the rent due date to the day that they receive their check. And then also utilizing the Ohio Relay Service. Some examples of reasonable modifications might include widening doorways, installing grab bars, lowering the heights of kitchen cabinets, installing a ramp, installing automatic water faucet shutoffs, installing or removing carpeting, lowering or raising the heights of switches, outlets, and thermostats, and then installing levered door handles instead of the orbital ones that you typically see on older homes. For reasonable accommodations and modifications, the tenant is responsible for requesting the modification or accommodation from the housing provider. The accommodation or modification must be related to the person's disability, cannot cause an undue financial and administrative burden, and cannot be a fundamental alteration of the normal service provisions. So for example, if a person becomes disabled and loses their income and they make a request to maybe perhaps have their rent lowered, that might be considered to be an undue financial and administrative burden for the housing provider. And therefore a housing provider would not be required to make that reasonable accommodation. However, A housing provider must grant the accommodation or modification if it meets the aforementioned criteria. So let's talk a little bit about your responsibilities as a housing provider when it comes to reasonable accommodations and modifications. You as a housing provider can ask for proof of the disability if it is not readily apparent. Asking for proof that the person with the disability requires the requested accommodation or modification because of their disability. And this can be proven by getting a letter from the tenant that is signed by their medical or social service provider or mental health professional or someone with intimate knowledge of the disability. A housing provider, however, cannot ask any questions about the nature or the extent of that person's disability, require the person with the disability to disclose their diagnosis, ask for medical records, ask how long a person has had a disability, or charge fees for any reasonable accommodations. Again, that's the changes in policies. Paying for reasonable modifications. It is typically the tenant's responsibility for paying for a reasonable modification. There are two instances when a housing provider may be required to pay for the modification. If the building receives federal financial assistance, or if the building was built for first occupancy after March 13th, 1991, and the modification is covered under new construction requirements, which we will talk about just shortly here. So the process for requesting a reasonable accommodation or modification, a tenant makes the request, and requests can be made at any time. The application process, before leasing up, anytime during the tenancy. You as a housing provider should document all reasonable accommodation and modification requests, including verbal requests. The housing provider must respond in a timely manner. Remember, if someone is requesting a reasonable accommodation or modification, it is because they can't enjoy the dwelling equally. So responses should be timely. A housing provider can ask for documentation if the disability is not readily known, apparent, or if the connection to the disability is not clear. Documentation can be provided by a medical, social service, mental health professional, or someone with intimate knowledge of a person's disability. The letter does not have to disclose the person's diagnosis, nature, or extent. It only needs to state that the person has a covered disability under the Fair Housing Law, and that it impacts one or more major life activities, and that the requested reasonable accommodation or modification is needed due to their disability. Now, new construction requirements. 7 require accessibility features on new construction. So when the Fair Housing Amendments Act was passed in 1988, new construction laws were put into place to ensure that multifamily housing with 4 or more units were built accessible for people with disabilities. Any building that meets that criteria must have the new 7 design features. This includes an accessible entrance on an accessible route. So thinking, can a person using a wheelchair get from the parking lot into the buildings? Are the doorways wide enough? Public common areas that are accessible. So public common areas might include lobbies, pools, picnic areas, mailboxes, and laundry rooms. Thinking, are these common areas accessible enough for a person with a wheelchair to access them? Usable doors. Are the doors usable by a person in a wheelchair? Are they wide enough? Is there a high threshold in the doorway, which makes it difficult to enter? Accessible route into and through the unit. Is the entrance of the apartments wide enough? Are there accommodations available for a person to be able to use a wheelchair to get from one room to another without encountering any narrow doorways or high thresholds? Then light switches, outlets, thermostats are in accessible locations. Light switches should be available, and temperature control areas are low enough so that a person utilizing a wheelchair are able to reach them sitting down. Reinforced walls in the bathrooms. This is in the event that a person needs to install grab bars. Are they going to be able to do so safely without the grab bars going through the wall? Then lastly, usable kitchens and baths. Can a person using a wheelchair easily access the sink using a parallel approach? If the kitchen is too small to accommodate a parallel approach, is there need space below the sink to make it accessible? These are the 7 construction requirements for new multifamily dwellings, again, 4 or more units that were built for first occupancy after March 13, 1991. Now to talk a little bit about prohibited acts. We've talked about covered property, protected classes. Now let's talk about what exactly is housing discrimination. It's the refusal to sell, rent, negotiate, or otherwise make unavailable or deny a dwelling. So for example, a family attempts maybe to rent an apartment. The landlord states that they don't allow children in their apartment. That would be a familial status violation. Discriminate in the terms, conditions, or privileges of the sale or rental of a dwelling, or in the provision of services or facilities. For example, a prospective tenant speaks with an accent, and although it is not your policy, a housing provider asks for proof of citizenship. This would be a national origin or ancestry violation. Make, print, or publish any notice, statement, or ad indicating a preference or limitation based on a protected class. You want to be describing your property and not an ideal tenant. Misrepresenting availability, denying someone a reasonable accommodation or modification request. In the event you have to deny a reasonable accommodation or modification request, you should always engage in an interactive process with the tenant. So, that you can see other ways that the person might equally enjoy the dwelling. And then intimidating, threatening, interfering with, or otherwise retaliating against a person who is exercising their fair housing rights. Lastly, in discriminatory acts, it's important to note that Ohio Fair Housing Law makes it unlawful to make any inquiry, elicit any information, make or keep any record, or use any form of application containing questions or entries concerning any protected class. Therefore, your rental applications should not be asking questions about a person's disability, race, or if they have children. Anything concerning a protected class should not be included on rental applications. And lastly, as we get ready to close, let's talk about consequences and goals of fair housing. So what are the consequences? If you're found to be violating the fair housing law, potentially a lawsuit or complaint and investigation, and if probable cause is found, then an administrative hearing where damages could be awarded, including compensatory damages, punitive damages, and injunctive or equitable relief. And for real estate professionals, possibly even a loss of license. What are the consequences of following the laws? One can be a force for good, working toward promoting the American dream of housing and home ownership for all. Avoid unnecessary fines and penalties or lawsuits, and the personal satisfaction of complying with the law and promoting everyone's right to equal housing. Housing is a critical facet of life, including physical and mental health, quality of life, access to education, economic outcomes. And so with that being said, safe, stable, and affordable housing is a necessity to achieving many other human rights. Therefore, accessing without barriers is critical. So you as a housing provider are doing the right step right now in ensuring that you are not being discriminatory by understanding your obligations as a housing provider. So lastly, I'll leave you with a couple best practices. 1, design a non-discriminatory list of rental criteria. Review the applications in the order that they are received, and then approve the first qualified applicant. Advertise your available unit, describe the property, not the people that you think may be interested. If conducting a credit and/or background check, obtain written authorization from the applicant and adhere to both fair credit and fair housing law. In 2016, HUD issued guidance on applying Fair Housing Act standards to the use of criminal records. If you haven't had the opportunity to take a look at that document, I would highly suggest reviewing it. Remember, everyone with a disability has the right to request an accommodation and a right to response in a timely manner. Document all requests for accommodation, including verbal, and then again, if you must deny, engage in the interactive process if the requested accommodation or modification has to be denied. Remember, a person is required requesting that so that they can enjoy the dwelling equally. And with that, if you have any further questions about their housing law and need some additional guidance, you can always give us a call or follow us on social media to get in contact with us. Thank you.
Thank you, Tanisha. Always some good information, good valuable information, and thank you for participating in this spring's landlord seminar here. And with more good information from our building department is the smiling, friendly face of Chris Parmele, our building commissioner. And Chris will be giving a presentation here, and following after Chris will be Andy Fleck from our prosecutor's office, and he will be appearing probably without introduction right after Chris. So thank you for being here this year. And here is Chris Parmele, our building commissioner. Chris, it's all yours.
Director Corrigan, thank you very much. Let me share my screen here. There we go. Thanks everybody for joining us. Morning, evening, early morning, late night.
Chris?
Yes.
It is not sharing. The screen is not on, at least on mine.
Really? Oh, there we go.
There we go.
There we go. There we go. That's better. All right. Again, morning, evening, late night, whatever time you're watching this, we appreciate it. It's important. There's a lot of good information in here. There's an extreme amount of information to go over. You can always reach out to the building department if you have a question, comment, concern. At the end of the presentation, there's going to be some phone numbers. I have some pretty good websites for you to view. So let's get it going. Welcome to Lakewood. Again, like Director Corrigan stated, my name is Chris Parmele. I'm the building commissioner. I've worked for the city for over 8 years now. My wife and I both live here, raise our kids here. Have almost 2 now that are going to graduate from high school, which is really hard to believe. The diversity we have here is amazing. You have every culture from every walk of life, every economic range, the walkability of the city, the architecture. I'm a glutton for punishment in old homes. We're unique. We're a close community. It's big small city kind of feeling, and we really appreciate the investment. If you're new to this, this is your first time being a landlord, thank you for the investment in the neighborhood. We greatly appreciate it. All right, a little bit of numbers here. After last census, we have 50,866 residents. We're canned on top of each other. 9,285, roughly per square mile. Most densely populated community in between San Francisco and New York, believe it or not. We have 180 miles of sidewalks. It makes us extremely walkable. 32,000 housing units. We're almost 50-50 when it comes to owner occupied versus rentals. Typical home value every year it's going up, and we're just under $260,000 now. 92 miles of roads, and we are in 5.6 square miles. So if you're not familiar with the city, there's some pretty neat numbers to look at. So how are you going to interact with the building department? Hopefully it's good. Just so you know, when you buy a rental property, everybody has to apply for and maintain a housing license. It's an annual fee. They're due November 1st of every year. You're notified via email, reminders about the housing licenses. So when you sign up, make sure you give us a valid email address. Being 2022 and the cost of everything going up, we don't send letters in the mail. We don't, send postage. The only letter you'll get in the mail from the building department, hopefully you will get one, is a correction notice. We're going to go over some of that stuff. So we do exterior inspections are completed from the right of way. So you have the curtilage line, front foundation building line. The building department is allowed on the front porch. That's where you invite the general public. That's where the mailman comes. That's where Amazon drops everybody's everything off. So we'll do an exterior inspection. We look at paint, downspouts, conditions of driveways, yard areas. We do safety and maintenance inspections. That is an inside, outside, full comprehensive inspection of the property. We try to do them every 3 years. Staff and timing and COVID, the past couple of years has made that kind of tough. So we're playing catch up. Once you become a landlord, once you have your housing license, you will get request letters for those safety and maintenance inspections. Don't just discard that letter. Make sure you respond back to us. We'll schedule a time. We're not out there to reach in your wallet and spend your money. We just want the properties to be maintained safe, clean, safe, sanitary, just like your house and my house. Make sure everybody's got a nice place to live. What we do is we call them certificate of code compliance inspections. Everybody else knows them as point of sales. When you go to sell your rental property, whether it's a single family, 2-family, 3-family, multi, mixed use, doesn't matter. We do a certificate of code compliance inspection on it. Again, that helps us maintain our rental housing stock and keep up on the properties. So like I said, when you go to sell, or if you even go to buy a new rental property, you're going to have a certificate of code compliance inspection. You're going to maybe submit plans for alterations, pull permits. Everybody's hot water tank goes out on them, new furnace. So we do permits. We give pretty good advice over the phone. We'll come and do a site walk with you if you have ideas. You want to build a new garage. We're pretty open. You call, we answer the phone. And we try to be as helpful as humanly possible. Again, housing licenses, we're going to go over that on the next couple slides, get a little more into that. And then complaints, your tenants, if they ask you to fix something and, you can't, you try to get to it within a reasonable amount of time. But if you dodge the tenants or ignore the tenants call us. We can't just go kicking the door in. The only way we can get in is if the tenants invite us into the property. We'll take a look at their unit, their concern, and then if there is something wrong, we will draft a correction notice. Correction notice will get sent to you, being the building owner, and we give you a time to take care of the issues. Not only the tenants can complain, but neighbors can actually complain about the tenants, neighbor squabbles, city officials, police officers, fire department. We get complaints about properties from every city division. Maybe even Director Corrigan's driving down the street and sees something of ill will, and he can pick up the phone and call me as well. A bit about that. Here's what we're going to talk about. We're going to talk about some seasonal responsibilities. All right. So grass, cut your grass. It's easy stuff. Cut the grass. If it's in your lease, the tenant cuts the grass, drive by your property to make sure the grass is cut. If it is over 6 inches in height and it starts looking bad, I'm going to call our public works department. We're going to come, we're going to cut it. We're not going to do as good a job as you. I guarantee you're going to do a better job, and it's going to look a lot nicer when you're done. And we charge you $250. Same thing if you're on a corner lot. Those bushes need to be maintained. You have bushes, shrubbery. Those bushes need to be maintained at 36 inches. That's for line of sight for vehicles, line of sight for pedestrians. That's really important. It's a safety issue. We had a fatal car accident on Marlowe about 4 years ago because of height restrictions and visibility issues. It's very important. Again, trim your bushes, cut your grass. We all have to cut our grass. I can say it 1,000 times. Cut your grass, cut your grass, cut your grass. You don't want to cut the grass. Number two, we just talked about 180 miles of sidewalks. We are one of the few municipalities in Northeast Ohio that don't bus students. Everybody walks to school. My kids, your friends' kids, we all walk. We're a walkable community. People walk to work. Elderly need to walk to go to their appointments. Handicapped people need to be on the sidewalks in their wheelchairs. It needs to stay accessible. Our codified ordinance 52106 tells you shovel your sidewalk. Shovel the sidewalk. I don't care if you shovel your driveway, but you have to shovel the sidewalk. All our lots are 42 feet wide. Shovel 42 foot of sidewalk. If it's in your lease agreement with your tenant and the tenant doesn't shovel the sidewalk, I and my staff don't care, because it is your responsibility as the property owner to shovel your sidewalk. It only takes a couple minutes. I don't expect you to shovel your whole block. If you have a snow blower and some extra time, buzz down the street, hit a couple houses, do your neighbor, help them out. Especially you folks that live around elementary schools. We have 15 schools in the city. That's counting private schools. Make sure you do your part and take care of it. It's really important. It's a big time safety issue. It's hazardous. And look at a kindergartner trying to walk through a foot and a half of snow. It's sad. So make sure you cut your grass, make sure you shovel your sidewalks. And again, whatever's in your lease, that's a lease. The city building department, we don't talk leases, we talk codified ordinance. Again, it is your responsibility as the building owner to maintain that. If you have any questions regarding any ordinances or anything like that, feel free to call our office and we can explain them to you if you don't understand or you need help understanding. Housing licenses. Every non-owner occupied single family, 2, 3 family, multifamily, apartment building, condo, vacant property, need a housing license or vacant property license. If you're the owner and you personally occupy the single family, it's obviously not a rental, you don't need one. If you occupy one unit of a double, you don't need a housing license. Once you hit a 3 family, occupied 3 family by you, housing license, single family home that you do not occupy, housing license, and 2 family if you don't occupy any unit, housing license, and so on and so on and so on. Housing licenses, as I said before, they're due, they expire November 1st. We usually open housing license season up around the beginning of August, so you can apply for your subsequent year. If you are a new landlord and you bought the house December 31st or October 31st, paid for a housing license, it's due again November 1st, you can call us, we'll work something out there. But every housing license is due November 1st. Every bit of notification we send you comes from our system. It's called Citizen Serve. Housing license reminders, your housing license, permits, plans, anything. Once you go in and you create a user account through Citizen Serve, register your rental property, then you can use Citizen Serve to apply for your permits, pay for your permits, you get notification when things are ready. You can snoop on your neighbors a little bit. You can see if there's any correction notices on any other houses. So again, any notification from the building department will come through Citizen Serve. So give us a valid email address, stay on top of your email. We send, when it comes to housing license, we send 5 to 7 reminders out a year prior to that November 1st due date. Depending on your email provider, check your spam. Sometimes, you know, they get trapped in a Barracuda or firewall software. Late fees are assessed after November 1st. Late fees can get really expensive. They're $25 per dwelling unit. So single family home, 25, 2 family, 50, and so on and so on. Keep up, it's your responsibility. Your housing license does need to be printed out and posted in a common area, multifamily, usually in a vestibule, 2 family, usually in a common hallway, side entry. And again, if you decide to sell your rental property, housing licenses are not non-transferable, so they need a new one. If you have any questions about any of this, feel free to give us a call. And down at the bottom of the page here, our codified ordinance 130643 through 130653 is all about what we just talked about. It's the legalese inside out of housing licenses and the responsibility of landlords. Right here is, we talk about the housing license application. You see that website, citizenserve.com/LakewoodOH. Go on, you create a user account, just like you do with Amazon, Target, any other online account. You have create a user account, fill out the application, apply, boom, it's easy. Fees are listed on the right-hand side of the screen. So your non-owner occupied 1 or 2 family structures, it's $75 per dwelling unit, and then it moves on from there. There is a limit for you folks that are buying, purchasing, or currently own large multifamilies. There's a cap, it's $3,500. So if you have a, 40, 50, 60 unit building, $25 per unit like that can get really expensive. So there is a cap. If you have a vacant property, maybe a family member passes away, you live out of state, but you want to hang onto the property. That's where the vacant housing license comes into play. That puts it on a list to let our first responders know, being fire and police, in case of any ill activity goes on. We know who to contact. If you have questions about housing license applications, that 529-6270 number, that's to the main desk. Or if you need any help with anything, you call the main desk. You can call me direct. If you go on the building department's website, on the city site, go under building department, there's a tab that says meet the building department staff. You can see all our smiling faces, email address, phone number, everything's right there. I try to make it as easy as can be to access us and reach out when there is questions. Couple quick resource links here. So there's your Citizen Serve website, Residential Code of Ohio. So if you're going to do any alterations, because there's two different codes we talk about. So there's the codified ordinance, that's local law. That's where the housing licenses and all that live. And then we have state law, the Residential Code of Ohio, that's based, or that's seated inside the Ohio Administrative Code. So Residential Code of Ohio is when you want to build a new deck, you want to, whatever the alteration is. That's a link to the code. It's free. I don't expect everybody to understand it. So if you have questions on building code, that's why we're here. Give us a call. We have a lot of years of experience downstairs. So we're there to help. Zoning code. There's a link to the zoning code. You can find the property maintenance code, that chapter 1306 we talked about. There's also some good stuff in the zoning code. How tall can I build a garage? How big? Our hours are 8 to 4, Monday through Friday. Main line 216-529-6270. You can shoot us an email, housing.building@lakewoodoh.net. And once you get done watching Andy's presentation and you're all wrapped up, there's a link right here on the bottom of the page. That's where you're going to get your completion form. And there's also a spot on the city website that you can fill in your information. Then that way we know you did your due diligence and took our little course here. Now this is the time where I usually do a Q&A, and there's always some good stuff, some witty banter out there. We're doing it remote. We've done this a couple of years now, and it works out pretty good. So if you have any questions, feel free to give us a call, 529-6270. You can call myself direct, 216-529-6295. If I don't answer, call me back. I'll do my best to call you back within 24 hours. And Director Corrigan, that is all I have.
Good job, Chris. Thank you, and thanks for all the work you're doing and you've done this past year. You have had quite a busy past year. So
yeah.
Yes. And our next speaker, as I mentioned at the beginning, is Andy Fleck. Andy's with the prosecutor's office here, and he will speak about the nuisance ordinance. So Andy.
All right. As Brian said, my name is Andrew Fleck. I'm the assistant prosecutor and the assistant law director here for the city. I run the city's criminal nuisance program. I'm going to talk to you for just a few minutes today about what the criminal nuisances are and how you can avoid one. As a landlord in the city of Lakewood, you can receive a nuisance notification letter from the city for any criminal activity that originates from your property and occurs over and over. Repeated visits from members of our different departments, building department, fire department, police department, are some of the more frequent things that do cause those type of responses. We feel that the owners of properties, landlords, are in the best position to take control of those nuisances. You are the ones that control who is renting your property, and you are ultimately responsible for the activity that's going on there. Well, maybe you don't live there. You are applying for licenses with the city and generating income from those rentals, so that we expect you to take responsibility and to take control of those situations. We've had this law since 2008. When we do send out a nuisance notification letter, it'll have an estimate in it. The estimate is for anything that the city has to use to abate the problem that's going on. So as an example, let's say that you have a frequent noise problem. One of your tenants plays their radio all the time and the police constantly go over to the house. After we've received a sufficient number of calls, we'll send you a letter. Dear Mr. Doe, that your property at 123 John Street has become a nuisance. Here is a copy of the calls that the city has gone on. Here's the estimate that it's cost the city $276 or whatever you may have in abating the nuisance and writing people citations or just going over and advising them to turn it down, whatever the situation may be. We're not required to write a citation in order for it to be considered a nuisance, just to verify that the activity is occurring and within 1,000 feet of your property. Once you don't have to pay anything at that time, but if we get a third incident at your property within 1 calendar year from the first date, then we can send you a bill from then on. These are the frequent things that we typically see as criminal nuisance: disorderly conducts, noise violations, drugs and gambling, littering, health and safety, alcohol, animal violations. The ones in red are the most common. Sex offenses, theft, weapons, vandalism, obstructing official business, building code things, high grass, weeds, rats, garbage on your property, any felony offenses. In 2015, I believe we added false alarms for police calls. Recently, in the last couple of months, we've added false alarms for fire calls. So be aware that having a alarm system at your property and not properly training people how to use it can generate a nuisance for you as the owner. The full representation of the Lakewood Criminal Nuisance Code is in Lakewood Codified Ordinance 510. I posted the link here so you can see how to get directly to that. You can read the code. It gives you kind of a more detailed explanation. I'm just kind of covering the bases here. Evidence of 2 misdemeanor or minor misdemeanor offenses or any 1 felony offense will trigger the writing of the nuisance notification letter. In addition, 3 false alarms in 6 months or 4 in a year will trigger that same letter. We send the letter out to the property owner. So a lot of times the letter is not going to the tenant. Sometimes if I can tell that it's not an owner occupied property, I do try to send the letter also to the tenant so that they're aware that this is a problem. But we do expect you as the property owner to be handling majority of that situation and not rely on us to be notifying your tenant for you. We expect you to respond with some type of plan of action. The best practice is to respond to us in writing and tell us what it is that you are doing or aren't doing, or what problems you're having with the tenant. If you've begun an eviction, how long you expect that would take. If you've properly screened tenants, all kinds of things. But response in writing is preferable. That way we have a copy of it. Email is acceptable. We can put it in the file and keep it in there so that we know how you're responding to the property. If we continue to receive problems, we haven't received anything in writing from you, we'll assume that you're doing nothing and continue to proceed accordingly through the nuisance code situation. Like we said, it's 2 minor or minor misdemeanor or minor misdemeanor offenses or 1 felony offense within a calendar year. If you receive a subsequent offense, it goes for an additional year from that offense. So let's say you had a violation on January 1st and June 1st, and on September 1st, we have your 3rd violation. We'll send you a letter. The look back period for the city purposes will be to January 1st. And if you don't have any more violations by January 1st, then you'll go back to the beginning. The process will be over for you and you'll start fresh. If, however, on December 31st, you get a new violation, it starts a new year at that point from December 31st to the following December 31st. And if you could go 364 days and another violation happens on December 30th, then you'll have another year from then. It's until you have a successful year from the first violation to the last without having any subsequent calls to your property for the same type of activity. The owner gets assessed if we get the 3rd one, it's called the nuisance declaration. you'll get assessed the actual cost that the city spends abating. So that's the time that the law department spends reviewing calls, the time the police department spends, the time the fire department spends, or building department, whatever department it is. If they drive any vehicles, how much gas, mileage, paper, stamps that we have to send the stuff out to you on, all of it gets aggregated. It'll be put on, like I said, the first estimate during the notification, and then it'll be sent as an invoice if you receive a third violation within the year. If you don't pay the violation, it is due within 30 days, then they'll put a lien, the city will put a lien on your property via the taxes, and you'll end up paying it that way. If you don't agree with the declaration of nuisance, you can request a reconsideration to the mayor's office within 30 days of the declaration. If the mayor decides to uphold the declaration, then you have the right to appeal it to the Board of Nuisance Abatement Appeals. It's very rare that we let things get to that level. Most of the time, we're able to work it out either by us notifying you that there's a problem at your property and you want to take action, or us sending a bill or two. Usually gets the job done. Kind of makes it easier for everyone in that way. We have had a couple cases go to the Nuisance Board of Appeals, but not very many. This is just touching on what I already said, the wage of the city people that are called to the scene, use of the vehicles, invoicing, issuance of the lien. Could be done through the auditor's office, or the city could take a civil action against you. If you do come before the nuisance board, you can prevail if you can prove that you weren't the owner at the time of the nuisance, or you were taking every feasible action to rectify the no nuisance problems. If you have a real problem tenant and you're doing everything you can, we're not going to hold that against you, but we are going to take a look at it. And if we can determine that you're not doing what you need to do to get the situation resolved for the neighbors in the neighborhood, the enforcement action is going to be taken on behalf of the city. Some successful things that people have done to show us that they're taking care of it: evict tenants, enforcing terms of their leases agreements, complying with your landlord obligations in ORC 5321.04. We've had over 400 properties that have been placed in the nuisance program since 2009. We've only had 6 get to the board to that level. Like I said, most of the times we're able to come to a satisfactory resolution. So how can you avoid getting to the point where you have a chronic nuisance occurring at your property? You can screen your tenants, doing background checks, searching court dockets. At least here, probably Cleveland, probably Cuyahoga County would be good places to start. All those are free. It's about, you can go on there. You don't have to put in your name. You don't have to put in anything other than a person's name, and you can see what kind of cases have been generated against them. You can see if they've prior been evicted. That's good information for you to know. If they have prior criminal history and whatnot, you can see all that stuff if you're looking in the proper court. Respond when we send you a notice notification. Call us, send us an email, something in writing. Hey, here's what my plan of action is. I'm going to do X, Y, and Z, so that we know that you're taking care of the problem. It's not going to be a situation where we're kind of allowing this stuff to cross in the mail and hitting you with violations that you've been addressing, but you just haven't gotten back to us. We want to know what you're doing right away so that we can properly decide how to proceed forward if we continue to receive calls. Ultimately, it's your responsibility. Your property is your responsibility, so you need to check on your property. If you live out of town, it probably means driving by every once in a while, see what's going on there, if the place is being kept up, if there's been any problems or whatnot. These are some resources for you. You can go to lakewoodoh.gov, as Brian said, put in here how to get exactly right to the landlord training seminar where the best practices book is. This is the link for that. So you can go to apply, register at the top banner, select landlord training seminar. All those information will be there. There's also information on proposed screening tools, rental agreements, crisis resolution, things of that nature. You know, this is an important part of our city. The city does have 52% non-owner occupied properties. So we do take absentee landlords very seriously. If you have any remaining questions, I've put my email here, my phone number direct to my desk. You can give me a call. You can send me an email with any questions you might have. And again, here at the end is another link just to the codified ordinances for the city of Lakewood. The nuisance code is under section 510. So you can check that out. If you have any questions, give me a call back.